Mr. Carruthers, you are charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 2nd, 2024, officers were dispatched regarding a major crash in Harris County, Texas. Upon arrival, the officers made contact with the wheel witness. The witness observed the defendant's 2005 gold Chevy strike an unknown person riding a bike with his vehicle.
Whoa.
Bike, yes, Your Honor.
Struck a person?
Riding a bike, yes, Your Honor.
Okay.
The defendant then got out of his vehicle and began assaulting the unknown person and then drove away from the scene.
Whoa. You're telling me he strikes someone in a car and then on top of it starts assaulting this person?
Yes, Your Honor. The unknown person fled the scene and the defendant was promptly found by officers 1 block away in a private driveway. That was not the defendant's residence. Upon contact with the defendant, the officer observed an odor of an alcoholic beverage, slurred speech, and poor balance. The defendant was detained. He refused SFSTs. The DIC was read. The defendant refused to provide a specimen. A blood search warrant was signed and executed. He was identified by his Texas driver's license.
I had just so many problems with this.
So, Judge, we have been unable to locate the unknown person that was on the bicycle. He fled because he was getting assaulted. We have no way of finding him.
Not only that, how do I know he's not consuming anything after the fact? How do we know he doesn't go home and chug a fifth of vodka?
This case unfolds like a slow-motion disaster, a man caught driving under the influence, the judge's tone cold and clipped, and the tension rising with every word. You can almost feel the courtroom holding its breath. The defense seems nervous, the officers unmoved, and the air thick with judgment. What started as a routine DWI charge is about to spiral into something much darker. Stay with me, this is where things start to unravel.
The DIMS does say he was promptly found by the officers 1 block away.
I get it. Yeah, I get it. Promptly is a conclusory word.
I'm pulling up the OR right now, Judge, to see if they have anything more specific.
Can I say something now? Don't, Mr. Carruthers. Don't. Are you losing? Are you losing?
No.
Then stop. Anything else? Was that it?
Looking at times, Your Honor, to see if we can establish when he was found based on when he was dispatched. I don't think we have anything additional, Your Honor.
It says, yeah.
Mr. Carruthers, I'm going to find no probable cause in your case. You know, we have enough death. We have enough dismemberment. We have enough blood all over our streets. Please don't add to it. Please just don't kill someone. That's all I'm asking you to do, man. You know, $40, an Uber will take you anywhere you want to go in this county. Anywhere. Please. Don't kill someone. Take a seat, please. Hi.
So, I have 2 clients I need to post for. The first one is Gallegos. So he did do his drug test, but it's today.
For
The THC, but I wanted to see if we can allow the actual results coming back from the labs, because my client was quite surprised about.
Okay, so we'll put it off 3 days, 4 days.
5 days.
Yeah, it takes about 5 to 7 days, depending
Okay,
on how.
we'll set it off a week. It's okay.
And then my other client, Your Honor, is Mr. Rando.
What's the last name?
Rando,
Is that
Fernandez.
Okay.
I'm going to address the bond that's set at 10,000 right now.
Page 32, Judge.
Yeah, thanks.
Judge, do you want to allow? But I'm addressing it.
Yeah, yeah, because I don't know anything about it.
Okay.
Yeah.
Yeah, no, Fernandez.
And hold on, Owen, let me just do this real quick, this arraignment. And while they're bringing him out, I'm gonna do an arraignment. All right. Are you Mr. Fernandez?
Yes, sir.
Morning, Mr. Fernandez.
Morning.
Sir, you're charged with terroristic threat of a family or a household member. You are facing up to a year in jail and or a $4,000 fine. The reason you're out now is your bond is set at $10,000, which is unusually high for a misdemeanor. I don't know why, but she's asking for a bond reduction. I'd like to know what happened in the case and we'll go from there. Okay.
On March 5th, 2025, an officer was dispatched to a family disturbance type call at a residence in Harris County, Texas. Upon arrival, the officer made contact with the defendant. And the complainant, the defendant's mother, was trying to make him leave the house because she felt like her life was in danger due to his behaviors and threats he made to kill her with a gun. The complainant provided text message from the defendant's therapist. The defendant also told his brothers about the threats. The defendant showed his 14-year-old brother pictures of guns and stated all of his friends have guns. The brother felt in danger. The defendant admitted he made multiple threats in the past of killing his mother with a gun.
So,
Did I hear a specific threat?
Not directly to the mother, but he had threatened to kill the mom to other people in the
But
family.
that's not, but a terroristic threat has to be aimed to a specific person
Yes.
and there has to be immediacy.
And my response to that would be that it was aimed towards the mother, threats to kill with guns while showing pictures of guns that his friends have access to shows immediacy. And to show intent to put her in fear would be a question for the jury of whether he intended to make her feel fear, whether or not it was directly to her or to others.
so I,
Where the threat is.
So, I mean, so he told his brothers that he was going to kill his mother.
And
That is what the complainant stated. I don't have a time. Oh, wait. As per mother, the last time the defendant had made those threats was 2 days ago. So on March 3rd.
that's not even it.
no, this has to be, it's something where, I'm going to kill you, MF, now. It's not, hey, man, I'm going to do this in a couple of days, when I get up to it, because I'm kind of lazy. I got shit I need to do. It don't work like that.
I understand. I'm just concerned, so.
Gotta be careful. You got but one life. How was jail?
I did.
Sucks, right?
Yeah.
I mean, we're not asking for much. All the knuckleheads that have guns that run in the street, they're gonna end up in here one day. That's all. I tell you, don't start asking anybody when you get back to the tank, Really, life is too short to live in a box like this. You don't need a gun. How old are you?
Just turned 18 on March 5th.
You don't need a gun. Get your ass back into school, man. Knowledge is power. You want to make some money? Learn something. She's amazing. Look at her. How much money you make? Don't answer that. She makes a crap load of money because she knows things.
Yeah.
That's what life's about. Fancy vacation, nice cars, these big ass beaches, blue water. That's what life's about. But you get it in school by gaining knowledge, not with a gun, right?
Mm-hmm.
I'm gonna find no probable cause. Do something, man.
Sure.
Get back into school, learn something.
He's in school, so he needs to finish school.
Yeah.
What
Hey,
he's going to
you're
do.
gonna get out today. Be somebody.
Yes, sir.
You're not a statistic. All right.
Thank you,
Thanks.
Honor.
Good morning, Judge. I got appointed this morning to Mr. Butler, first name Philander. And Your Honor, he has a pending felony case. However, I did see that he made bond on that one, and this is the only thing that's keeping him in custody right now.
What would you like?
Your Honor, and realistically, I talked to him to see if there's any means for his family or friends to go ahead and pay this bond, which I ultimately would be around 100. He didn't provide any information on that. He's actually not sure how he made bond on his felony
You
case.
got a PR bond on it. So it looks like he picked up a UUMV February 24th. And now he's picked up a misdemeanor theft. I guess they haven't gone back or looked. I don't know what they're going to do. He's set for 331 on that case. I don't know if they're going to yank the bond on that or not. I don't know. But he wants me to give him a PR bond.
Yes, Your Honor. I do have contact information. I have an address for him as well.
Hey, Deputy Miranda, do you mind bringing up Mr. Butler? Yeah. Give me a second. Let me do an arraignment real quick and then we'll talk to Mr. Butler. Good morning, Mr. Butler. How's jail?
Not good.
Great. That makes me happy because the harder time you have, the more we have them for a reason. Here's the rub. Your lawyer is asking for me to give you a PR bond in this case.
That's it.
You were on bond for an unauthorized use of a motor vehicle,
That's it.
and now you've picked up a theft case. I have no idea what happened on that theft case. We're going to figure out what happened real quick, and then we'll talk about your bond.
That's it.
You have the right to remain silent. Anything you say can or will be used against you. You're facing a Class B theft, so it's up to 6 months in jail and or a $2,000 fine.
On March 7, 2025, an officer was dispatched to a theft call at a Target in Harris County, Texas. The defendant was observed on surveillance video placing merchandise in a black suitcase he also obtained from the business and crossed all points of sale without attempting to pay. The defendant was detained without incident. The total value of items stolen was $355.46.
So you said he also has a lot of
No, that was Mr. Phillips.
Mr. Phillips has that account.
Yes.
Miss Keela Lee?
How old is Mr. Butler?
He's 25 years old, Your Honor.
Miss Keela Lee?
Miss Lee? Judge, I was looking, I did not see any sort of history of him not showing up for court or any sort of bond forfeitures on his previous cases.
The problem is you keep picking stuff up. Stop. I don't want you to say, but my problem are two things. Number one, sometimes people are their own worst enemies and they continue to pick cases up there. They're just, it can't stop. I don't know. But you, Mr. Butler, you're 25 and you have now 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Now you're on your 13th and 14th case. And a lot of these are very serious felony cases. Unauthorized use, robbery, unauthorized use, felony fraud, evading in a motor vehicle, felony theft. Now another unlawful. Why? Why would we continue to give you PR bonds when since January, you're on your 4th case? Why?
Soros.
The thing that you need to consider, Mr. Butler, is it would only cost literally $100 to get you out of jail right now. And there's no one there to pony it up for. These are the things that you need to consider when you're out there in the free world, because you were in the free world just now and you picked up a theft case. But you need to start thinking, well, even if I pick up a case where it's $100 to get out, I have no one that's going to get me out. Why? Why would we continue to, tell me.
And Your Honor, as the state mentioned, he hasn't forfeited any of his cases before, although he does have other cases. There's a few that you mentioned that were dismissed ultimately. And he has already provided me contact information. Keep in contact with me so that he's not a flight risk. He is originally from Houston, so he would show up to court.
But I don't want you to pick up any more cases.
That's it.
Right. In the short 2.5 months in this year, you're working your 4th case. I can't give you a PR bond, man. I don't want you to pick up the 5th. Bill comes due, Mr. Butler. And now we'll see. I'm sorry. He's working for his 4th case within the last 2.5 months. It's not going to happen. I don't want you to pick up a 5th case. I'm sorry, man. I don't know if you're going to get out now, but if you do, you're not allowed to go to any Target stores anywhere. Do you understand? Okay. All right. I'm sorry, Mr. Butler. I can't just keep
Thank you, Your Honor.
How you doing, Your Honor?
Hello, Ms. Lee. Ms. Lee, you were charged with theft. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have
I'd like to take notes.
Sure.
You said theft, 1 year in jail,
You're facing up to a year in jail
up to 1 year,
and or a $4,000 fine.
and or a $4,000 fine. Proceed.
We're going to do probable cause.
I don't even remember what that meant. I haven't been to court since 2006.
We're going to see whether there's sufficient probable cause to go forward with your case or not.
Okay.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed to you if you cannot afford one. You ready?
What do you call that attorney that's
Court appointed lawyer.
pro bono? Proceed.
Judge, do you mind giving me a cause number? It's not appearing on my docket.
I have,
Hey, please.
oh,
A certain process we follow. I don't want you to engage with them.
I was just,
It's okay. 255.
It's
4005.
so 255-4005.
Correct. And go kind of slow because she's taking notes.
Yes. On March 2nd, 2025, at approximately 2:30, officers were dispatched to a theft at Memorial City Mall at Macy's. Upon arrival, the officer spoke with the complainant, who stated he noticed the defendant conceal a tester of perfumes in her bra. A different associate also noticed and asked the defendant to put the perfume back. The defendant did give the perfume back to the associate. Once the associate walked away, the complainant observed the defendant pick up the same perfume and conceal it in her bra, and then later put it in her purse.
I didn't even, in this,
The defendant walked past all points of sale without paying for the merchandise. The complainant stated that 4 tested perfumes were seen being concealed on CCTV footage, and 4, Your Honor. And another 4 were located on the defendant once she was apprehended by a supervisor and the complainant. The total value was $1,321. The defendant admitted to the officer that she did steal the perfume and that she tried to exit the store before she was apprehended.
Okay, what store are we talking about?
This is a Macy's at Memorial City Mall.
Okay. Ms. Lee, I'm going to find that there's sufficient probable cause to go forward with your case. I am ordering you as a condition of your bond not to go back to any Macy's and not to go back to Memorial City Mall.
have already informed me that,
If I find that you go back to the mall, if I find that you go to any Macy's, I will revoke your bond. I will put you in jail.
Okay.
Please do not pick up any new cases. Likewise, if I find that you pick up a new case, it's not going to go well. Would you like to apply for a court-appointed lawyer, ma'am?
I would, sir.
Okay. So Deputy Miranda is going to give you an application for a lawyer. I need you to fill it out for me. I will have you go to Ramona, sign a reset, and then we'll just have you take a seat wherever you'd like. And then just please fill it out. And when you're done, you can bring it back to us.
Officer Fleischer, I know you did mention that anything I said will be held against me. May I please say something?
Please don't. Let me give you a lawyer first. You tell the lawyer, and if it's
Okay.
appropriate, then they
Okay.
can tell me.
That's-
Okay?
Okay.
But I really don't want you but you can tell the
Period.
lawyer.
I'm sick. I got a liver disease and I can't go to jail.
No one's going to jail today.
No, I mean, I wouldn't live there. If, I'm not gonna make it. I have too many health issues, but
Don't worry, man.
thank you so much, Your Honor.
We're here to help.
Thank you so much, Your Honor.
Yes, ma'am.
It's gonna be a reset.
Well, I'll have you talk to the lawyer, but most likely it'll be reset. You're, Mr. Solange. Sir, you were
Yes.
charged with terroristic threat.
Amenazas terroristas.
You were facing up to 6 months in jail
6 meses en la
and or a $2,000 fine.
de $2,000.
We're going to do probable
Vamos a leer
cause.
causa.
You have the right
Usted
to
tiene el
remain
derecho a
silent.
mantener silencio.
Anything you say can or will be used against you.
Podría ser
You have the right to have an attorney present. If you cannot afford one, one will be appointed
uno
to
se le
you.
nombrará. Ok,
On February 9th,
el 9 de febrero de
2025,
2025,
an officer
un
was
oficial fue
dispatched
despachado
to a
a una
residence
residencia
in regards to a
en cuanto
disturbance with
a
the
un
weapon.
disturbo con un arma de fuego.
The officer met
El
with the
oficial se
complainant,
reunió
who
con
stated
la
that he has
denunciante
ongoing
que declaró que
issues
tiene problemas
with his neighbor
siguen
over
con su
parking.
vecino sobre estacionamiento.
The complainant stated
El
that today,
denunciante
while in his
dijo que hoy,
driveway,
mientras estaban en la marquesina,
his nephew told him to get
su
down,
sobrino le dijo que
after he
bajara.
observed the
Después que observó
defendant
el acusado
point a rifle in the
apuntando un
direction
rifle
of the complainant.
hacia la dirección del denunciante.
The complainant
El
stated
denunciante
he feared
dijo
for his
que
life
temía por su
and
vida
ran to call the
y corrió a
police.
llamar a la policía.
The complainant's wife
La
filmed
esposa
the
del
defendant
denunciante
pointing
dijo
a
que el acusado
rifle at the complainant.
apuntando un rifle hacia
Officer observed the video
Los oficiales
footage in
observaron
which the
la
defendant
cinta
is
donde el
wearing a white
acusado
tank top
tenía
and black
una
shorts
camisa blanca
while
y
holding what
con
appears to
pantalones
be a
cortos.
black rifle.
Entonces tiene en sus manos algo que se
The
parece ser
officer
un rifle.
observed the
El oficial
defendant facing
observó
it in the
el acusado
direction of
mirando
the
hacia la
complainant's
dirección
residence
la
and
residencia del
positioning himself
denunciante
to aim the
y
rifle.
posicionándose de manera de
The
apuntar
defendant
el rifle.
then
El
disposes of
acusado
the rifle
entonces
in
se
a nearby
deshizo del
shed
rifle
once
en
he
una
realizes
silla
he is being
cerca,
filmed.
ya cuando se da cuenta que lo están
The
grabando.
officer
El
next made
oficial
contact with the
entonces
defendant
hicieron
and
contacto
observed
la
the
segunda vez,
defendant wearing the same clothes
observaron al
as
acusado
in the
con la
video
misma ropa que
and
estaba
standing
en la
next to the
cinta
same shed.
y corriendo hacia la misma caseta.
The defendant was then detained.
El acusado entonces fue detenido.
The defendant
El
stated
acusado
he did not
declaró
have any
que él no
weapons
tenía ningún arma de fuego,
and then stated
ningún arma.
that the
Entonces
rifle was
dijo que el
hidden
rifle
inside the
estaba
shed.
ocultado dentro de la caseta.
The officer found the
Los oficiales
rifle
encontraron el
and
rifle y
determined it was an
determinaron
airsoft
que
rifle
era un rifle
similar
airsoft
style to
similar
a real assault rifle
a un
and
verdadero
can
rifle de
cause serious
y
bodily
podría
injury
causar
or death.
lesiones físicas muy serias o hasta muerte.
Mr. Salash, I'm going to find that there's sufficient probable cause to go
Causas
forward with
para
the
seguir
case.
adelante con su caso.
I'm ordering you as a condition of your bond not to have any contact with the complaining witness and not to be in possession of any
No tengo
weapons.
posesión de ningún arma.
Has he since moved? Because I'm going to order
Me preguntaron
like
si se ha
200 feet
mudado
as well, that he not go near the complaining
más
witness.
cerca de
No, Your
200
Honor, he
pies.
still lives in the same
Vive
residence.
todavía en la misma
And the
residencia.
complaining witness actually
Y
lives across the street.
él, de hecho,
And it's a
vive
two, I
cruzar la
it's a
calle.
two-lane, I looked it up.
Y hay de
It's a
dos
two-lane street,
sentidos, una calle
with
de
opposite
dos
direction
sentidos
traffic.
con el tráfico que va
I think
pues
it's
uno al
probably
otro.
outside of that
Yo creo
200-foot
que está
boundary,
fuera, más allá
but
de
it's
esa,
across the street.
I'm
de
ordering you
200
not
pies.
to
Te
go
ordeno que usted
200
no,
feet of where
menos
this
de
person
200
lives
pies donde vive,
or where this person works.
donde trabaja
I
esa
do not
persona.
want them living in
Yo no
fear.
quiero que vivan en temor.
You understand?
¿Entiende?
Okay.
Okay.
If I find that you violate these conditions,
¿Sí,
if I
no?
find that you put my public in danger, I will revoke your bond and I'm going to put you in jail.
Lo voy a poner en la
I
cárcel.
don't know what your immigration status is, but if you're not in this country with permission and you go to jail,
Yo a la cárcel,
immigration finds
encuentra.
you because they sweep it every day.
Ellos van
They
todos
will put an immigration detainer on
en la
you and
inmigración.
you will be stuck in there until this case is over with and then shipped off to immigration. If you were able to get out of immigration on an immigration bond,
Una
you
fianza de
best
protección,
behave. Because anything goes wrong,
cualquier cosa,
you will also lose that immigration bond and all that money you've paid
todo ese dinero que has
will be
pagado
someone else's.
será de otra persona.
Do you understand?
¿Entiende? Yes, yes.
You have a lawyer.
Tiene un abogado.
Because you have a lawyer, I will waive your
Abogado.
appearance. But it is your responsibility to stay in touch with Mr. Paz, and he will tell you if and when you have to
Le
come
puedo
back to
decir
court.
cuándo tú tienes que venir a la corte.
Thank you.
If he tells me he cannot get a hold of
Que no
you
se puede-
because you were playing games and you're not responding to his phone calls or text messages, likewise, I will
Llamadas,
revoke your bond.
también revoco su fianza.
You
¿Lo
understand?
entiende?
Sí.
Yes.
Okay.
Está
Do you
bien.
mind filing those conditions?
Absolutely.
For now, we will
Por
have you
ahora.
sign a reset with Ramona.
Otra
After that, you will take a seat in the jury box while we get your bond conditions. We will have you sign it,
fianza, usted le
and
va a
after that, you'll be free to go.
Entonces, después de eso, está libre para irse. Okay,
Thanks.
yes.
Thank you, Your Honor. Thank you for working with us and letting me have time to get out from immigration. May I be excused?
Yes, sir. Thanks. What happened?
Nah, it's just,
You okay?
yeah, thank you.
Looks like,
It's not convincing.
I know, I mean,
I get over it.
with us here on this
No, it's
case?
just, no, it's not a big deal.
Okay, all right. I don't want to press. Hey, how are you, man? How about that thing with the,
It went well. I did so well, they invited me next. Yeah. It was good. They asked a lot of questions. They asked a lot of interesting questions, even.
That's good.
It was good.
he was talking to a high school.
He was talking what?
It was a high school, right?
It was.
Yeah.
I did a high school presentation about knowing your rights, so I focused on some
Oh,
personal.
by the way, did you talk to Greg about that? He has that,
Thomas?
yeah, it
Yeah,
was,
I
it's a,
told him. Yeah. Sometimes they don't put it on the face of it and I have to do a little digging, so I did a little digging. I sent it to.
did they have a search warrant or something? They
This
just,
is the warrant, so they got him on this warrant, but yeah.
but they just started taking other things as well?
Oh, I mean, inventory, because they can't take them to jail, Judge. I don't know what was taken, but I mean.
A computer,
Oh, I can't.
I'm sorry, or was it an iPad?
You said iPad and some money.
iPad and money.
Sure, it's in a bag somewhere, but I mean, obviously for a motion to restore, I won't, oppose unless there's something in the computer that's objectionable.
So this is Mr. Carruthers, right?
Yes, Judge, this is Mr. Hakeem Carruthers.
Good morning, sir.
Morning.
So we brought you out today, well, because we're talking about you, and it's only fair that you get to hear what we're talking about. Your lawyer, I'm assuming you're asking for a bond. Okay.
Yes, Judge, we're asking for a bond.
I don't know. I have to get to know you in about, 2 to 5 minutes, who you are, right?
Yes, sir.
Who you are. It's not what you tell me, because everybody tells me something. Paper really tells me who you are, your past, your present, your potential future, because that's how I get to know you. So I don't even know what you're wanted for. Okay?
Your Honor, he's wanted out of Shelby County in Tennessee for assault, bodily harm, resisting official detention, and vandalism, 10,000 to 60,000. They all arose out of the same transaction where he had a disagreement at a Dollar General store, and he flipped the cash register, and among his damage, he ended up injuring the cashier's hand. And then obviously when officers arrived, it wasn't peaceful. It was indicted on.
Did you say it wasn't peaceful?
It was not peaceful.
Okay.
Hence the resisting. It was indicted on January 17th. In his history, it's going to show a second warrant, but it's only because it was previously charged on September 28th, 2023, and then it was indicted in 2025. That's why it shows two, if that's how it shows up. But it's only one offense.
Can't imagine it's even worth it. Really?
So the work.
It's a rhetorical question. You don't have to answer, but I'm saying, Dollar General, man. Life's too short. Any priors?
No priors. It's only an extradition because the vandalism is a felony. The other two are misdemeanors. State's not opposed to a bond.
I'm down. Dude, really? All this because Dollar General store? Really? Hope you got it. Get it. Life's too short. How long's it been in?
Since last Wednesday.
Wow.
Right?
That's a long time. Okay.
6, yeah.
So tell me,
The biggest thing, Judge, it sounds like this wasn't indicted until January 17th, 2025. We're at March 10th.
Yeah, sorry.
And so there's no failure to appear. I'm assuming there's not like he's been
I'm okay
running
with giving you a bond.
500.
Well, I don't know about
I
that.
was gonna say 5,000. For what it's worth, Shelby County did want us to request no bond, but I stated that the court would likely give a bond because of no priors and because it's not an aggravated offense. But for what it's worth, is they were still intending on picking them up. But
What do you think as far as a bond?
5,000, just because of the nature of all that combined to cause $10,000 to $16,000 in damage with just I mean,
How
obviously.
much
it's
in damage?
10 to 16,000. I don't know what it is in center because the sheriff's office there wasn't able to look too far into it. And obviously I haven't called the district attorney's office there, but that's the range because of felony.
Have you spoken to what he can make?
I've spoken to him. He's going to be counting on his family to help him out. That being the case, would you consider 2,000? I think that's sufficient enough to where he hasn't had an opportunity to
Let's
mess
take it
up.
lower.
Lower, perfect. Go lower.
You get but one life, Mr. Carruthers. You either live it good you live it bad, or you spend all that time in a box. It's just not worth it over something so silly. It's just not worth it. I'll set your bond at $1,000.
Yes,
But I
Judge.
want you to understand, we don't play games, right? We give you 2 weeks from the date of your release to go turn yourself in to, you said Shelby County?
Yes,
Tennessee.
Tennessee. If you don't do it, there will be drastic consequences. It takes forever for Tennessee to get up here. So if you don't make it up there, you don't turn yourself in, I'm going to revoke this bond. I will set it at 0. I will not give you another one. Do you understand? And then this time I will issue a nationwide warrant. I'm going to get you eventually. You can't run forever. And then this time I will hold you here until Tennessee comes and gets you. You get one shot, do the right thing. You understand? Okay, bud.
The only thing is, Judge, I don't think you signed the waiver or a refusal, so.
No, I showed the refusal. I sent
Signed?
you. I sent it to you.
Oh, I haven't seen that. The one I saw wasn't signed by anybody. Okay, so he would have to sign a different document first.
No, the refusal stays. He just signs the reset to.
Yeah,
And that's
it's-
it.
because he's a refusal, he doesn't have to sign anything.
Okay, perfect.
Yeah, it stays and he just signs the reset.
Knowing that he's got the 14 million. Okay.
Yes.
Sounds good, Judge.
Okay.
Was I there to turn myself in and then go see what they talking about? Because I was down there for a whole 2 years and I went to Lakeside. I was admitted
What
there.
happens is when you go turn yourself in here or over there, when you go turn yourself in, this fugitive case gets dismissed. You don't have to worry about this anymore. Then you just got to go fight that down there. Right? But you got to go turn. Is there a bond set there now?
30,000.
So
Once he self-surrenders.
once you go there, at that point, you'll be able to post a bond to get out. And that bond over there is set at 30,000. Okay, and then you can get out and fight the charges on the outside, but you got to go there first, and we have to know that you turned yourself in. Okay, all right. Good luck, man.
Thank you, Judge.
Hi, Mr. D.
Yeah, may we approach Judge?
Please.
Judge, we want to be transparent with you about this case.
Uh-oh.
This Gerard Jones is the young man that picked up the murder case. We don't know how long you want to carry it or if you want to carry
Is it on docket today?
Yes, sir.
We know that that case is going to take years. Right?
Murder case, yes, sir.
And then we have the 2 assault and mischief.
I had asked the state, would they be amenable to dismiss it and use it for punishment in the event that he gets convicted?
Yeah, I'm still, I mean,
Spoken to the
I'm still waiting to hear back from the
big brother.
Yes. I made the offer, but I understand Mr. Dixon's point is not want to take anything. I totally understand that. I totally understand that. But I can talk to felony. Just would ask for quickness. And I mean, I don't think the defense going anywhere.
I mean, really, don't stress. Life's too short. So you want a week? A week?
Yeah, we could be fine. Thank you, Your Honor,
So
today.
set it a week, see what you're okay, and then if not, then we'll set it.
Yes, sir.
And I'll email.
You want to talk to me?
Yes, Judge. Madam McIntosh, Judge, he was, law enforcement. Right now, he's in jail on 2 theft cases. And I was wondering, would you be amenable to giving him a bond on these cases?
Is there not a bond set?
I think it's 5,000 a piece, Judge.
So, yeah, the old one is 5,002. You want me to talk to him?
I talked to him, Judge. He wanted me to, I wanted to see if you, Judge, would be amenable to giving him a PR bond. Take that as a no, Judge.
I don't know. Look, I never want to say no.
Yes,
I gotta
sir.
talk to him, but he picks up a theft case, takes off, and the only reason we got him now is because he picked up a new theft case.
That's correct, Judge.
If we give him a beyond again, a new bond, are we gonna get a 3rd theft case? You know, I don't know. Let me talk to him and then we'll see.
Okay.
How's jail?
Not too pleasing, not too pleasant.
It's supposed to be like that. Right.
Yes.
Here's the problem. Your lawyer wants me to give you a PR bond, but you picked up a theft case. You're supposed to come to court. You didn't come to court. You took off on us. We issued you a warrant. We issued a warrant. The only reason we have you now is because you picked up another theft case. So why? Why would we continue to do the same thing?
I attempted to come to court, but you see, there's no buses coming out of Kingwood. And I was taking care of my grandmother in Kingwood. So I tried, we tried to get Uber money and everything, but I couldn't make it. And I called in and
We don't have any record. The only reason we have you now is you picked up a new theft case. What happened on the theft case, Alex?
So on the most recent theft case on March 6, 2025, the officer was dispatched to a shoplifting call at a Walmart. The officer made contact with asset protection, who stated that he recognized the defendant from a previous encounter and observed the defendant grab multiple items and attempt to leave the store, passing all points of sale without attempting to pay. The defendant stated he is owed a Purple Heart Veterans discount. Therefore, the amount stolen should be less than listed due to the father's military service. The defendant stated he was trying to find his ID that he dropped outside the Walmart, and that is why he passed all points of sale and attempted to leave the exit. And the defendant further stated that the warrant should be invalidated due to him not stealing on the prior theft as well. The total was $283.62.
It's all not how it went.
No comments on the facts of this case, sir.
Okay.
Was he ordered in the first theft case not to go back to the, so they're both at Walmart, right?
I just want to confirm. No, the first one at a Melrose was the first theft.
Melrose?
Yes, Judge.
It's Melrose.
I believe it's a retail clothing store, so my understanding is.
Are you sure?
Let me double check what that is. Yes, Judge, it's the clothing store.
Do you see any other prior criminal history?
I see only a previous interference that was dismissed, but nothing else besides that.
What do you think, Mr. D?
I think that I think he would conform to the requirements, Judge. He stated.
Didn't before.
I understand. He made a mistake there. We all make mistakes in life. He said that he was attending to his ill mother, that that's not a reason for him not to show up.
I just turned 30.
What do you do with yourself these days?
I'm a farmer in the Virgin Islands. I have a farm. I'm a COO of True Farm Hydroponic Goods. We have a farm in Florida, Palmetto, Florida, and we have a farm in St. Croix, U.S. Virgin Islands. I'm trying to expand to make a ranch over here in Houston.
Who do you live with now?
My grandmother, she's battling breast cancer.
Here's the thing. If I give you another PR bond, and that's a big if, I don't want you out on the street because I don't know what you're doing with yourself. I don't know who you have in your life now. So the first thing that I would like to know is that if we give you a PR bond, where are you going to go? If it's out on the street, I'm not going to do this again. But what I'd like is to see, if you don't mind, reaching out to maybe any family members to see who he has there to go home. If you have, you said grandma, if you have a place to stay, then great.
Now, here's where the story twists: an assault charge added to the list after a shocking hit-and-run incident. You'd think remorse would follow, but instead, there's defiance and confusion. The judge's patience wears thin as the accused stumbles through excuses. It's chaos cloaked in legal formality, and every second feels heavier. This isn't just about alcohol anymore, it's about accountability unraveling live before us.
We can verify that so that we know that you're going to go. And the next thing is, if I give you a PR bond, I'm going to put a monitor on your ankle so I know where you are, because you're a flight risk. You've already proven to us that you're a flight risk. And so I'm concerned if I give you a PR bond, you're going to take off on me again. And I don't want that to happen, because I'm not going to play this game with you. You know, fool me once, shame on you. Fool me twice, shame on me. So if you already fooled us once, I'm not going to do this again. So what I'd like to know is if you have a stable place to stay, and then we'll go from there. So you mind reaching out to see if he has a place to go to? If grandma will take him in, then I will give you one more chance, but it's going to be with a leg monitor so I know where you are. And if I find that you ever go back to a Walmart again, away go all your PR bonds. You know, you now have no one that's going to bond you out. So the next time someone alleges that you commit something and you end up going to jail, you will be stuck like Chuck in there because no one is going to post your bond. This is what you need to think about when you're out there in the free world. Do you understand?
Yes, sir.
If I do this, what's going to happen? If I say this, what's going to happen? That's what you need to think about. So let's see what we can do about finding you a place. And then if so, we'll go further. All right?
Okay.
Okay.
I take care of it right now.
Thanks.
Yeah, since I'm here, on Mr. McIntosh, the one we just spoken about the place to stay, I spoke with his grandmother, Mrs. Gladys Sanchez. Mrs. Sanchez informed me that she would be willing to let him stay there for a period of 2 months. If he tries to get a job and stays out of trouble, she's willing to do that. She said she can't let him
That
stay.
sounds fantastic.
She said she can't let him stay there indefinitely. She can't let him stay there indefinitely because he is not on the lease. But she is willing to make a sacrifice
So
of
what
2 months.
do is we'll bring him out. And then we'll give him 2 weeks to see what he's done to get a job. We'll go there. If that's also a condition of his bond as well.
Yes, sir.
You know, we'll put a monitor prior to release so we know where he is.
Yes, sir.
No dope, no alcohol.
Yes, sir. Fair enough, Judge.
So we know he's not using.
Yes, sir.
That's it after that, right? We're done?
Yes, sir.
What's up?
Deputy, how'd you going? Deputy Miranda. When someone works in jail, do they get paid? Isn't it true they get like maybe 5 cents per hour or something like that?
Somebody now they get like more for 3 to 1, depending on as a worker, they get more time, more pay. So no, instead of sometimes they do 1 to 1, the workers don't get 3 to 1. That's no.
But they don't get like any kind of real money, no real money. It's only you're working for time.
So you work for time, pretty much 3 to 1.
What I was gonna say is you can either get a job in the real world and make real money, or you can work in the jail. Because if you want me to let you out, there's a couple things you need to do. Number one is get a job. Your grandmother is willing to let you stay there, but not indefinitely because you're not on the lease. So you have a limited amount of time that you can stay there. The other thing that you need to do as part of her condition for you to live with her is you got to get a job. Do you understand?
Yes, sir.
People who don't have anything can't be picky. So don't be picky where you want to work. Any job is a good job as long as you're making at least minimum wage and it's verifiable employment so that we know it's real. Okay. I'm going to give you another PR bond now, but I'm not going to do this again. If you pick up a third case, I'm going to go absolutely bonkers. You know, no one's going to bond you out. So think before you act. You are not allowed to go to any Walmarts. And I'm going to bring you back in 2 weeks to see what you have done to get a job. You must put in at least 10 to 15 applications. It doesn't matter where, Lowe's, Home Depot, McDonald's, don't be picky. You have to get a job.
Yes, sir.
The other thing is no dope, no alcohol.
Yes, sir.
I'm going to test you. I'm telling you now, I'm going to test you on your release so I know that you're not using.
Yes, sir.
You understand?
Yes, Your Honor.
Give me questions. Job. Drug and alcohol free, and be nice to your grandmother. Because if she's nice enough to give you a roof over your head, don't bite the hand that feeds you, because then your butt's gonna be on the street. Do you understand?
Yes, sir.
Anything else, Mr. D?
No, sir, that'll be all.
Okay. You will get a GPS prior to your release so we know where you are. And I want you back here in 2 weeks to show me what you've done to get a job. If you have done nothing, it's not gonna go well. You understand?
Yes, sir.
Okay, all right. So good luck, Ms. McIntosh.
Thank you, Your Honor.
Judge, keep the bonds as is, but PR bonds?
Yeah.
And then,
On March 2nd, 2025, officers were dispatched to an accident call at the 4500 block of Southwest Freeway. The defendant was passed out in the passenger seat of a tow truck. The officer noticed that her eyes were low, that her speech was slurred, and that her breath smelled like alcohol. The defendant urinated on herself. The defendant stated that she had one drink and that she was coming from a club. The defendant showed to be lethargic behavior. The defendant confirmed that she was the driver and that nobody else was with her. SFSTs were conducted. It was a 6 out of 6 on the HGN, a 6 out of 8 on the walk and turn, and a 1 out of 3 on the, a 3 out of 4 on the one leg stand.
You're driving. All we have is her admission that she's driving.
Well, yes and no, Your Honor. We do not have anybody that put her driving. Anybody that sees her in the driver's seat. I spoke with the officer on Friday after we left court. He stated that once he was dispatched, the defendant was no longer in the driver's seat of the vehicle, but the vehicle is on the scene, clearly having front end damage. The officer speaks to the tow truck driver who was there and stated that and learned that that tow truck driver did not see her driving, but another tow truck driver was there on the scene earlier, and that when there's a lot of tow truck drivers. When the tow truck driver arrived, the other tow truck driver and the defendant were standing outside of the vehicle speaking. So we never.
No one even saw her in the car.
No, Your Honor. However, this is on a major freeway. I could pull up Google Maps if that's good for you.
No, I believe it. I get it.
There are 3 lanes to the left of traffic. There are 3 lanes to the right of traffic. There is
How
no
could you
way.
put her otherwise.
A way for her to leave without honestly being run over. And that's the case law that I've shown you, that she admits to driving, and that
The problem I also
along
have
with
is-
the conjunction of that there's no other way for her to get there or to leave, and that is enough to
Was there any
show up.
alcohol in there? Any?
In the vehicle. No, we don't have any open containers.
Did you provide me case law that says that an admission is sufficient?
It's an admission along with corroborating evidence that shows that there's no other person that could have been driving. And
There was one thing, she also denies driving, correct?
Yes, no. So on Friday, when I spoke with the officer told me that she did not outright admit to driving, and that is correct. And through my notes that I emailed him, I put the defendant denied driving. That's not exactly correct. What the officer did say is asked, where are you coming from and where are you going? And she answered those questions. So based on that information, we can say that she was admitted to driving.
I can't say that. That's assuming. You can say, oh, I went there, I went here. I didn't drive here this morning. I took the bus this morning.
She also admits that she was in an accident. She stated that she hit because they're at the same time they're investigating FSGI.
That's new information. I mean.
It's in the body cam, Your Honor.
Okay. So I wasn't privy to that last week. Again, so now we're on her statement only. So I'll wait till they're done. I'm gonna
Sorry.
wait, yeah.
No, just that she said that she was in an accident because they're investigating FSGI, and the defendant stated that she hit some sort of. The officer is asking, did you hit another vehicle? And she says, no, I hit some sort of barrier.
Okay.
And then the FSGI, they're unable to charge that case because they can't identify who the driver is.
So the complaint, there's a separate white car that's been in an accident off of the freeway. They're trying to connect this defendant to the FSGI. That driver of that other vehicle, the complainant, isn't able to say who hit her. So we did not accept those charges.
Do you have a case that says that an admission?
Yeah, that's the case. Reed, I sent that by email. It's like a 1957 case. The state, they gave you Dansby.
Case from
Huh?
It's a case from 1852?
No, my case, 1957. Yeah. That's why I was like, everybody knows this. Corpus delicti. That's in the state's case. The state cites to Fisher, which is the same proposition that.
Fisher, the conclusory case?
I'm not sure if that, no, you're thinking Ford. No.
Oh, yeah, Ford.
Yeah, in Fisher, they talk about the corpus delicti rule, which is the defendant's initial.
Traditionally, I agree with you, right? Like the statement in and of itself is insufficient.
Right.
When you have other evidence there, like what she's saying, corroborating evidence, you know,
No, I would dispute that. They're saying that her being on the highway alone, it'd be the other way around. If she was in a parking lot alone, the case they presented to you, it's a lighted parking lot. It's more likely that.
she's in the middle of a freeway.
Right, so it's more likely you're not gonna find someone that's left the scene as opposed to if you're in a parking lot with lights and street lights, you're probably gonna find that person walking down the street.
And Your Honor, we'd argue that if they're in a freeway, there is nowhere for another person to go. The person would not exist.
How could there possibly be someone else? I mean, if you're.
There's all kind of places you can sneak into. There's sewer, jail.
But this is why.
You can walk into the store. Yeah, I'm just telling you, I don't know why we're assuming everything they say is like grace. In the case they presented to you, there was a restaurant where the defendant was found. Today, they've said that my client admitted to owning the vehicle. I'm not aware of that. That wasn't presented to me last week.
It's in the DIP summary, Your Honor. And the officer did run the car and it did come back registered to the defendant.
So again, that would be from her statement, unless there's some hearsay that they are now saying that corroborates that. In the case they presented, there's a bar nearby that where the person that is the defendant claims they were at drinking. The way it was presented last week is, I went here, I went here, I went here. It was, I drove there. There was no admission to driving. You still wouldn't have a witness to say that she was operating. Did you get my email? Because I want to make sure.
I'm reading through now.
That's the original one. Yeah.
What's the
whole?
Is it still good?
Yeah. There's nothing.
Have you seen 3?
Sorry, Your Honor?
That's the one I sent.
Did you send it to them?
I have seen them all, yes, Your Honor.
And it's an oldie but goodie. That's exactly the same situation. And then
No, it's like right on point. It's like here we have, except for the fact that like in 3, he's at a hospital, makes an admission. Where here, she's still on the scene.
And see, that would be our.
she's in a record car.
Okay, meaning, but she's still
They're right next.
close to the car.
And that would be our argument, is that distinguishing 3 from the case that I presented to you is that in 3, the defendant's not on the scene. Somebody else could have driven, as opposed to the case where I showed you, which showed defense counsel and you as well, Your Honor. It is a Whataburger parking lot, I believe they're in, maybe a
Right.
McDonald's. It's a fast food restaurant. The defendant is found inside the restaurant and the car is outside of the restaurant. But the court found that based on the totality of circumstances, looking at the surroundings, that the defendant's admissions combined with the fact that it was his vehicle, that he was right there, that it was enough to prove operation.
Yeah, and that's the distinction that I think, is important, because all of that is near itself as far as premises and the defendant. Everything here is not near the scene. It's not all one little package. I don't know where she
Why
went.
not? What do you mean? Why not? The only difference here is that she's sitting in a record truck, but we have.
No, they said that she went to all these places that I don't know where they are, or if she went, and so in this case, they have evidence that she was
So
going.
the officer, hey, where are you coming from? Where are you going? And she says, hey, I was,
Coming from a club.
dancing.
Right,
Whatever.
whatever. In San Antonio, I don't know. I don't know where that club is. That's what I'm saying. And here, they know where the Whataburger
Is it relevant? Where? I don't care. Where? My only concern is she driving. I
Right.
don't care where she goes.
Exactly. And that's where, again, she's not saying she drove there. She's saying that she was there. So
I'm just saying that she was going home, Your Honor.
someone was driving her home.
What's the exact statement that she says?
Don't have it was on the body cam, but I have from the offense report, if I can pull that up.
Why don't we put it off till tomorrow so you can take a look at what she's looking at? That way you can make an informed argument, Are you okay with that?
No, I'm good anytime. I'd like to postpone Always. So I'll come back tomorrow.
I asked the suspect where she was coming from. She stated Good Moods, a club in Houston, Texas, and that she was going home.
So I go home, someone asks me, where are you coming from? I'm coming from the courthouse. Okay, they don't know that I took the bus there, back home. You know what I'm saying?
But she's alone. Her car's in a ditch.
I don't know, again. I got you, or
I
I
mean,
see.
take a look. We can finish it up tomorrow. I mean,
Mhm.
I'll take a look. If you have any more cases, just
But I
let me
do
know.
agree with you that that case is on point, and then I do want to point out that from last week to today, and I'm assuming tomorrow, the facts are gonna keep getting different, you know. from
Take a
the-
look and take a look at everything. Release everything so that
I
he can.
have, yes, Your Honor.
Absolutely every single piece that's out there.
I got you.
See? Yeah. Okay, Mr. Pond, thanks. All right. So gentlemen, both of you guys have worked out agreements in your criminal cases. You've worked out an agreement where, Mr. Jones, your case, you're charged with criminal trespass. Both of you are charged with criminal trespass. Yours, Mr. Jones, it's elevated to a Class A misdemeanor because it's a trespass of a habitation, shelter, superfund, or infrastructure. So you're facing up to a year in jail and or a $4,000 fine. But you have worked out an agreement where they're offering you 39 days in jail with credit for the 3 days that you've done. As a result of this plea bargain, they're going to dismiss 3 other cases. Is this how you understand it? All right. Mr. Smart, you have worked out an agreement where you are entering into a 2-year deferred adjudication. This is a type of probation that if you complete it successfully, you will not end up with a conviction on your record. You need to understand you give up nearly every right known to man by entering into this agreement. If you violate this agreement, then we will issue a warrant for your arrest, put you in jail, and you're looking at up to 180 days in jail. But I'm telling you now, we will continue to do this treatment program until it takes. If you take off on it, if you don't complete it, if you don't do the aftercare, I will issue a warrant. I'm going to put you back in jail, and we will start the program new and fresh every single time until it takes. Do you understand? The only thing I'm asking you to do is stay clean. That's all I want. This is literally all I want. Don't kill yourself slowly. Don't kill yourself at all. Do you understand? You must do substance abuse treatment as indicated by the TRAS that you have done. You will do what's called SAT. This is an inpatient facility that you're going to go to. The program lasts around 9 months, give or take. It depends on how well you respond to treatment. If you do well, if you do what they ask, then it goes shorter. If you fight with them, it's going to take longer. It could be a year and a half. Do you understand? So both of you give up the right to a trial, right to compel witnesses to testify on your behalf, confront.
And just when you think the chaos ends, another case begins. A new defendant steps up, this time facing terroristic threat charges, and the mood shifts from frustration to disbelief. The courtroom transforms into a stage of raw human tension, guilt, fear, and pride colliding in real time. The judge stays composed, but the room vibrates with unease. These moments remind us, justice isn't just a system, it's a mirror showing who we become when rules break down.
And cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Now yours will reflect as a conviction on your record. From now on, you're facing a minimum of 90 days in jail. Do you understand? Mr. Smart, if you complete this, you do not end up with a conviction on your record. You understand? How do both of you plead to the offenses, guilty or not guilty? I'm not going to find you guilty. I'm going to withhold that for 2 years. You're entering into this probation, and I'm telling you, all I want you to do is be clean. Can you get it done? Yes. I really, really hope so. We're going to keep doing it until it takes, one way or the other. Did you have anything that you wanted to add?
That's it,
No?
Judge. Thank
Okay.
you.
Anything?
I'm gonna wait to see you.
I'd like to go through it. You're smart.
Okay.
So maybe like 4 months in,
Okay.
let's go pay him a visit. I'm gonna go visit you to make sure that you're doing well.
Yes, sir.
You're not going to treatment. If you're going to treatment, I'd visit you. You're not going to treatment. And I don't even know where you're gonna go. Good luck, gentlemen.
Thank you, Judge. Yes.
Thank you, sir.
Yeah.
Judge Fleischer, she wants to thank you.
All right.
Just make us proud.
Yes.
Make your sons proud, Mrs. Smart. Okay, thank you. Good morning, Mr. Torres. Sir, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and a $4,000 fine. You have worked out an agreement where they're offering you 50 days in jail with credit for the 2 days that you've done. You need to understand that this charge is going to go on your record. It's going to be there for the rest of your life. It's even there after you die. This is important because if you ever get pulled over again and you smell like alcohol, you smell like dope, what's going to happen? Up to 10 years. Cops don't care if you're falling down stupid ass drunk. You don't have to be like that. Just the faintest smell of alcohol. You get pulled over, an officer's going to run your license. They're going to say DWI, DWI. Well, he's probably DWI again. Put him in. 2 to 10 in the penitentiary next time. If I were you, even if you've had a sip of alcohol, I wouldn't get into a car. It is a huge risk. Not to mention how much money have you paid for all this? You know what I mean? $40. Uber will take you anywhere you want to go. Don't matter where you want to go. $40. Use it. You have the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never take off. Do you understand? Yes, sir. I didn't plead to the offense, guilty or not guilty. Yes. I'm going to find you guilty. I have to suspend your license. I will suspend it for a year. Do not drive until you get a license. Now, when did he want to report for the jail time?
The 24th, Your Honor, 2 weeks from today.
Okay. You must report by 6 p.m. on that date. If you fail to report, I will issue a warrant for arrest. And then you're looking at up to a year in jail. Do you understand? So to report by 3/24 at 6 p.m.
And Your Honor, I don't know if I don't want to interrupt you, but just regarding court costs, if you would consider running them concurrently. I was retained, but Mr. Torres is I believe he's indigent. He's on SSI. He's on disability. And he also uses Medicare for his insurance. He's not working because he has a.
You know, in life, we are allowed to make mistakes, right? But when you continue to make mistakes where you endanger other people's lives, everything gets just so much worse. You know, I routinely, when I have a DWI first, I routinely run court costs because there's also a surcharge on your license of $3,000, perhaps $4,500 if you have a high breath test. It's a $6,000 surcharge on the DWI second. Why would I continue to reward you? What do you do for a living, sir?
I'm not staying at home.
You don't work? What's the nature of your disability?
From the car accident.
He has it's a broken.
Because of your car accident in this case?
No, previous one.
Previous.
He had one in 2011, Your Honor.
And now we're here on DWI second. Was it due to another DWI?
Yes, Your Honor.
When do we learn? When do we learn? What is it going to take? A death? Lose a foot? What happened in the accident?
I had to be life-flighted.
Holy crap. Are you lucky to be alive?
Sir.
And here we are yet on a DWI, a new DWI. I'm suspending your license for 2 years. I don't want you anywhere near a car. Don't drive. You scare me when you get into a car. You're lucky to be alive. Much less, what about the rest of our, what? You know, my family's on the road all the time. I had a good friend a year ago die from a DWI. What? The reason that we have all these surcharges are because sometimes jail is not enough to get your attention. So now the legislature has made it to where somehow we got to get these people's attention. So let's just start hitting them where it really hurts, and that's in the pocketbook. This is a $6,000 surcharge, not to mention court costs, $6,500 that you'd be rolling out of here with. What do you think? They want me to roll the court costs. I will make you a deal. I want to see something proactive because I'm not sentencing him yet, and I can continue to sentence until the 24th of this month. Show me some proactivity so that we know it's not going to happen again, and I'm happy to roll the court costs. But I want to see something proactive from you so we know that you've learned something. Don't write me a letter. I get enough letters. I don't need a letter. I want something really proactive on your part that shows me that it's not going to happen again. We're not going to see that you've learned something from this. And if you can be proactive, show me something, then I'll waive your $6,500 in fines and fees. And this is important because if you don't pay it, every $100 you owe, you will sit 1 day in jail. So you can imagine how long you will sit on a $6,500 surcharge. You have 2 weeks to really knock my Aunt Connie's socks off. Do you understand? Okay.
Okay,
All right.
thank you.
We've got 2